Okay, welcome everybody. This is part 3 of the 2014 criminal traffic case 66525, which is the state of Florida versus Doss, which is me. My disclaimer, as always, is I'm not an attorney. I don't practice law. I don't give legal advice. If you want legal advice, seek an attorney and be advised. For the full disclaimer, go to the website www.gregdoss.com, gregdoss.com, and you can contact me directly. The contact information, as you can see, is located at the bottom of your screen. Now, this is the second motions hearing before Judge Conrad, which is this will be on June 19th. And by the way, shout out to everybody taking the time to listen to my story. And by the way, if you like the video, please like it and share it with your friends. Now, most of the interruptions, as I was saying before, is probably more so from the passion of my ignorance to the law and legal procedures in the process up to that point. You know, I spent a lot of time doing some YouTube surfing and get my information from various sources. And many of those sources, in fact, actually none of them had any proof of the way that the traffic situation was supposed to work. But hey, it is what it is. I took the time to apply myself, learn information, and from there I've naturally graduated to a greater understanding. So without any further ado, let's get to the case of State of Florida versus me.
All right, State of Florida versus Sir Greg Doss. Good morning, Mr. Doss. Let me just try to get caught up as to where we are in your pleadings. I have a notice of hearing and notice of special appearance that seems to have been filed on June the 17th. Included in that is a number of paragraphs, 1 through 8, 9, 10, 11, 12, and 14, which are entitled Demand for Dismissal. And paragraph 13, or item 13, is a notice of challenge to statute and motion to intervene. It also looks like you may have brought by this morning a notice of constitutional challenge to the statute and motion to intervene, and that might be what's represented in paragraph 13 of your other motion. So it looks like that may just be a little more information on that one item. Is that correct?
Well, somewhat, my honor, but the record does reflect that I'm here under special appearance. There was a question as to whether or not the challenge to the statute was received beyond this office or to the clerk. So I went and refiled it, which would mean that within 30 days, if the if the attorney general doesn't bring it in, validating that, then the case got to go. But at this point, we couldn't move anyway. But I just went ahead and did it because they said it didn't receive the stamp from the clerk. So I went to the clerk this morning to make sure there'd be no issue. And now this
Are you prepared to go forward on that or not? On that issue?
No, I just received it yesterday.
No, this morning.
This morning.
Okay.
So well, if she has one within the office, because I have to certify another one to pay a bond, that would mean I have to certify my only copy. So possible.
Bonnie is the Attorney General, right?
Attorney General.
Let's see.
Yes, sir.
Well, let's do this. Let's go through the ones that we got notice of, which would be the notice of hearing, notice of special appearance, and scheduled this morning. And we have item number 1, demand for dismissal and no delegation of authority signed by the Congress of the United States. Didn't I rule on this last time?
No, sir. We said you were going to take a break. We're going to rule on it this time relative to whether or not it was germane only to federal courts.
Yeah,
Right.
We ruled on some of these counts that are in this motion. Maybe
Right.
not all of that.
Those things which are relative to the discovery questions, specific to, I guess, the cause and action.
Let me go back.
Cause of action.
In that argument, it looks like you're arguing pursuant to the United States Constitution, I believe.
And let me say this again. One thing I know I definitely needed to work on at the time, and probably to some degree may even today, but I'm not so bad today, is the allowing them to finish before speaking. That's very important so you get the entire context.
in Article 28 United States Code Section 3002 that there is no delegation of authority for this court pursuant to federal law. Is that fair or not?
Well,
fair?
Article 3 is the Constitution, where it states that the judicial power of the United States is vested in one Supreme Court, and such superior courts as Congress may from time to time ordain and establish. Now, through Title 28, Congress does define courts, which the title doesn't supersede the Constitution. And Article 6 of the Constitution makes that clear, that nothing supersedes that. The issue becomes, one, if this venue is a legitimate court, then show me the proof of that, and everybody has the right to that. Because if it's not, then we might actually be in the wrong venue to even bring an action.
But let's go back to that issue. Is there any other legal grounds? Because these are legal issues. These are not factual issues necessarily. It's a grounds for dismissal. And you're arguing legally that this court does not have jurisdiction based on what you believe federal law states.
I would think factually, because I've actually asked the court to produce the authority for the 13th Judicial Circuit to exist. And if they can't produce it, then it's to be construed that they don't have it, because that's also a jurisdictional issue.
Okay. All right. So you want to have any response to that or not? Okay. Here's, and again,
her refusal, her not responding is not an indication that I've caught him on anything that matters or anything of significance. We've all probably heard plenty of stories about courts and their ability to exist. He's going to go through a professorial and probably 6th through senior year of high school civics lesson along the way. I would say this: I don't have any proof based upon my experiences that a lot of this stuff that I raise at this time even matters, whether it's delegation of authority and all the stuff regarding oaths and who people are even matters. What matters is, was there probable cause for the stop? Was the stop justifiable? Did all necessary elements involved with the charges, were they able to substantiate them? Would they be able to substantiate them in a court proceeding? And as he mentioned something about whether things that are legal issues, maybe from a procedural standpoint may matter, but the more important part is, was there a factual basis for whatever led to the citation itself? Not some of this other stuff that essentially, like I said again, is more or less the passion of my ignorance at the time. So just keep that in mind as you take notes moving through this the rest of this presentation.
As mentioned to you earlier in what prior court dates, I may have a different understanding of the law that you have. I don't have any qualms with you asserting what you believe in, but at some point we may not agree on what the relevant law is and what should be applied. And obviously, given my responsibility, I get to make that decision in this court. And obviously, there's other courts of redress if you feel like your rights are violated. And you understand that.
Overstand, yes.
Yeah, well, here's the deal. Under Article 5, Section 6 of the Florida Constitution, that vest actually creates county courts of jurisdiction, okay? That Constitution controls what the court system is in the state of Florida. I don't agree with your assessment that I'm controlled by the United States Constitution in terms of the court's jurisdiction. I don't agree that 28 United States Code has anything other than dealing with federal courts. States have inherent power because they are states to actually create their own system, legal system. And as long as the fundamental right is not violated, that's protected under the United States Constitution, those courts actually have both standing, jurisdiction, and authority within the parameters of the state's boundaries, okay? So under Article 5, Section 6, the county courts were created and vested with specific jurisdiction, okay? And pursuant to that, and I'm also going to refer to Chapter 34 of the Florida statutes, which actually creates specific courts, but under Article 6, Article 5, Section 6, that the county courts shall exercise the jurisdiction prescribed by general law. Right. What that refers to is laws that are implemented by the legislature under their authority pursuant to the Constitution. So, for that reason, and again, we have a different assessment on what applies, but what I want to do for you, Mr. Doss, is try to be very specific in my rulings so that if you, at the end of the day, don't agree with those, you have a record that clearly states what my thinking was, and that can also be reviewed if you think it's appropriate. So I'm finding, as far as the requirement of delegation authority by Congress of the United States, I don't need that authority. The authority that I have is vested under the Constitution of the state of Florida, specifically Article 5, Section 6, and therefore promulgated with Chapter 34. And under those two areas of law, I have jurisdiction over this matter. So as to ground number one, I'm going to deny your demand for dismissal for those reasons.
Okay.
Number two is a demand for dismissal for not providing adequate discovery. We discussed that issue before, and I don't know what they have or have not given you. So is that an issue that's still pending?
Right. And if we refer back to Article 5, which before we move forward, I want to get back to the delegation issue.
Because I'm going to make my ruling. I'll give you that. I'll give you one more opportunity. But your record's clear, and I'm making my ruling very specifically. And I'm not going to argue with you whether you're right or wrong. I don't agree with you legally, and so we can respectfully disagree.
Okay.
But go ahead. If you want to address another issue as to that, you can put it on the record, and then we'll move on.
Well, I'll just object on the record, because there's also within Article 5, which makes this function also an administrative function, but I just want to put that on the record as an objection, and I'll expand that with the 5-4, but okay, we can go on to the second one.
Okay. Did the state provide you with information they believe they're required to do under the laws of the state of Florida and the rules of criminal procedure?
Now, I can't speak for what they might have thought they were giving me, but rather...
What don't you have that you think you're entitled to?
Okay, that's a little different. Okay, their discovery is insufficient in as much as all I'm gathering from the discovery as I've read it, and I actually had a copy of the the citation report of the so-called arrest incident prior to my time coming in. I'd already went and got one myself. The state provided essentially actually exactly the same thing with I guess a couple of additions. This discovery is not sufficient in as much as it doesn't even answer the demands of the writ of discovery. It seems to be just like a templated document, which is fine, and I don't want to say this or allude that I think that the state is intentionally withholding information, but I do have case law that would show or support that if I ask for something specifically, those things specifically must be granted.
Let me ask you this, and you're speaking in general terms, I'm just trying to get to specifics. What do you think that you're entitled to that they have not given you?
Well, I asked for video because I believe that by SOP, all of the police cars are equipped with cameras. So I wanted to see what, in fact, the officer alleges to have seen relative to his engagement to me.
So you asked for video?
Yes, sir.
Okay, Ms. Cavalcante, there is no video.
Not all police cars are outfitted.
Did you respond that there's no video?
In the discovery, would say if there was video, there is no video.
Okay, so there is no video of what transpired apparently with you and the officer that day, and obviously they can't produce something that
does not exist. So, and there's no affidavit, unless there's no sworn affidavit by anyone stating in fact that I committed any crime. Okay, before we get to dealing with the whole crime issue, because they can stop you for traffic violations and what have you, let's not forget the states have the authority to make and create their own set of police laws, police powered laws, as well as they have an obligation to look out for the best interests of the general public, which is why they essentially, well, I shouldn't say that's why, but that's one of the reasons why, as the people of the state, we gave them certain authorities to our legislatures to pass laws that help protect the public interest. Now, policy violations can potentially lead or give grounds for dismissal of an action. And also what was pretty interesting is that the state attorney made a reference or made a statement about police cars, and I guess at the time I wouldn't have known, but I could have asked her, is she making that as a statement of fact? are based upon her opinion. And don't forget, she can't issue as a statement of fact, and her opinion doesn't really matter. Again, that's not legal advice. It's just my so-called legal theory and my position on it, because attorneys can't testify to things that they don't know anything about. Actually, no one should testify to something they know absolutely nothing about.
Is there a citation?
There's a citation.
Okay. All right. So did you get a copy of the citation?
The citation copy is in here.
Okay. And what other information in terms of written documents exist that relate to the charge that you're aware of outside of the citation?
None. The
Okay.
police report which we have provided.
So there's a citation and a police
And
report.
a police report and a driving history, all of which were provided.
Okay, so what they're saying in terms of, and you're, I don't know if you're making a Brady argument or something else. What they're saying is that they've provided, and I know you understand this. I'm not trying to talk over you, because I'm not. You understand this fairly well, and better than most people that have been in my courtroom, and I respect that part of it. But I want you to, there's an element of legal requirements that they have, and if there is written documents relating to that, they have to produce those. And what they're suggesting is there's no video, and whatever they have in writing that was generated as a result of this, they've given you the citation report and your driving record, and those are the documents that they would use potentially to prove the case. And that's it. That's all they have.
So,
and we'll put that on the record.
I appreciate that. You've been more than gracious with this. Now, if we move back, the citation defines what the officer or officers, according to this, Hessler and James, which are names that are different than what. And I guess if the last three numbers after these numbers, and I don't know if the deputies will know or somebody can verify, if those are the badge numbers, those badge numbers are not consistent with the badge numbers that were given on the citation.
Yeah, that I don't know. I mean, if there's an issue with that, I guess that issue would be relevant in terms of cross-examination or impeachment or something along those lines. But go ahead.
There has been an amended discovery provided to Mr. Doss, adding a witness. So I just wanted to put that on the record that also has been provided as soon as it came to my attention.
Does it relate to his question or not?
No, I just wanted to make sure that it is aware that
You have
those
disclosed-
two are not the only two witnesses, because I amended discovery last week.
Yeah, you have disclosed all the witnesses.
I disclosed all
That
witnesses.
you're going to go over.
I will call.
I don't have that amended discovery.
Well, it was sent to the address that was given in court.
Okay. When was that sent?
I don't have the file on me. It was sent last week. I checked in my system.
And let me go back before I digress too far. One of the things that you've identified in your motion, I forgot which document it was. You claimed that the case is not set for trial. I believe the case is set for trial.
At the time that I did the original filing, the case had not been set for trial because let's not forget, I did it, and you read this to the record last time. I did a notary presentment that I had no contract.
You were here on May the 7th.
That notary presentment thing matters probably not at all. I don't have any proof where a notary presentment in and of itself would keep the court from prosecuting a case where they had met all the other necessary prerequisites to try a case. And I don't think I ever saw a police report in the record, so that's kind of interesting after listening to it now and again. I haven't really taken the time to scrutinize any of these cases in many, many years. This case here is actually 7 years ago that I was even engaging in any of this stuff. The other thing is, don't forget the citation is a charging document. So it's sort of like when you get a citation, it's like being arrested. Even if they don't take you to jail, it's an arrest, because essentially a police officer has broad discretion in many cases anyway as to whether or not they arrest you. Now they don't have any discretion if they come in contact with you and there's an outstanding warrant, then they must execute the warrant. But other than that, everything else is pretty cut and dry so far with the case. And he mentioned a couple of other things. He'll probably clean them up a little bit later on down the line, as I remember. So I'll catch up a little bit later on. Let's get back to the case at hand.
Arraignment 2014, and on that day I immediately set the case for trial for July the 1st at 9 o'clock. So the case has been set for trial since May the 7th.
Okay.
So just letting you know that it is set for trial. I don't want you to show up on July 1st and say, hey, Judge, this case hasn't been set. And that's one of the reasons I wanted to accommodate your motions, because I didn't want to delay the trial. I wanted all of your issues resolved before then, and that way, if we needed to proceed, there wouldn't be any outstanding issues in terms of your ability to prepare.
He's protecting the state. Well, he's just doing what he has to do procedurally, but this so that we don't run into any issues involving speedy trial and the case is summarily dismissed because of a speedy trial violation or something that could win on an appeal regarding a speedy trial issue.
Okay, well, I wasn't aware of this.
Is it in virtual file or?
It hasn't been put into the virtual file. It is the individual who was added to the official notice of discovery is the police report, so he has not noticed that he's read the police report.
Who's the individual?
I'm not on notice for the report. I'm on notice for the discovery.
Well, no, what they're saying, if they give you a police report, and in that police report, there's a list of witnesses and references to what that person may testify to, that they have, in fact, you are on notice as to the existence of that witness potentially. I haven't read anything. I don't know.
Okay, well,
Do you have a report?
I have this discovery, and the report is. I did read it. No, was the report amended or just the discovery amended?
The discovery was amended to include the witness that apparently was in the police report. And so, do you have the name of that person? Or
if I looked at the report, I can tell you.
Tell him.
I'm guessing it might be Weiss or Weich. If that's the case, then I'll have to go ahead and do a depth one. Actually, I'm going to also definitely I'll be filing a suppression here because they have the citation, but what there is nothing alluding to is the actual rising cause of action.
He is correct. It was Deputy Weich.
Okay, so those are three potential witnesses.
Okay, that's fine. Okay. But there is nothing that's defining the crime that caused the interaction. So
there doesn't have to be a crime to cause the interaction.
Okay.
In other words, and again, I don't know what's in the police report, Mr. Doss. I don't get those documents. It's not my function to review that information beforehand. So you know, and the state knows more about what allegedly happened than I do. But I don't have to know that. That's not my job to read all the police reports and do all that.
Let me say this right here is a general issue. The judge rules on matters of law and the discretion on what they bring into evidence based upon rules of law. Facts are determined by a jury or a trier of fact. If the judge is the only person trying that issue, then the facts are then at that point taken into consideration. So I just wanted to make sure I said and spoke to that. And I did mention the issue of potential suppression hearing, which I know I had brought up before. Let me say this also: the entirety of not the entirety. Sometimes people think that traffic infractions are, because they're not crimes, don't allow a police officer to engage you. That's patently untrue. So don't move forward thinking that you can just say because it's not a crime, as I did in my ignorance here, saying what's the crime. I should have just said what was the cause, the reasonable suspicion or the probable cause of them stopping me at the time they made the stop.
I rely on what's produced at trial, and that's the only thing I consider in these cases. But go back to the issue of failure to provide adequate discovery. It looks like they've given you every written document that they have. They've given you a list of all the witnesses that they have. And so outside of something else that I'm not sure you're requesting, I'm not sure, there doesn't seem to be anything else legally they're required to give you. So what else do you think you should get that you haven't got?
Okay. I'm unclear, so I'm going to ask the court for clarity.
Sure.
Is it the court's position or the law that a police officer can engage somebody simply for going about doing something that otherwise is not? In other words,
that's not a crime.
It's not a crime.
Yes.
He can engage.
Absolutely.
And then I guess the
absolutely.
Court will provide.
Let me give you an example. I'm on a highway, the speed limit's 55 miles per hour, I'm going 75 miles per hour, officer stops me for speeding, it's not a criminal offense, but it is a violation of Florida law, and is a civil infraction, and a law enforcement officer not only has an obligation, but has the legal right to stop someone, detain them for purposes of issuing a civil citation for violation of a civil law or civil infraction. And so it doesn't have to be criminal in order for a law enforcement officer to stop you, detain you, limited detainment for purposes of issuing you a citation for a civil traffic violation.
Okay.
That's my belief as to the law.
And he also spoke to the fact of he said limited detainment for the purpose of issuing a citation. And again, he's correct in that. So let's just make sure that we don't continue with a lot more of the things that have gotten a lot of people in the trouble that they may not have needed to be in, when you could probably find a number of other reasons or a number of other flaws in the case that the state may have against you based upon the information that was relayed from the police officer.
Okay, now.
And again, you may not agree with it, but
Okay, now I'm going to look for the case law because I'm going to say specifically if.
let's go back to the discovery because
Okay, well, okay, that's one of the things I asked for in discovery is what specific event occurred that would have had him engage me at all?
Okay, so do you have something along those lines in the report? Do you have a reason for the stop in the report? Where's the file?
The file is at the office, I'm assuming, because it's not here.
I have the police report.
That's the technical police report, that's not.
Well, okay, here's what I'm doing. I'm gonna get frustrated because I'm asking questions. I want those questions answered, and I'm not getting the answers now. So we either will take 5 minutes to get the file in here, or you can answer them from the computer. But there's no reason not to have a file in here with the information. I don't understand that.
Judge Conrad is doing a decent job, and I think I was extremely blessed, or there was a watchful covering over me to have him first, because had it been a number of other judges, especially some of the ones I encountered after him, my entire journey may have been different, or could have just been totally derailed to the extent that I never could have recovered. So he was of great benefit. He's almost, again, he's just like a professor. He's teaching us, he's giving us a civics lesson, and at the same time doing an outstanding job of giving examples, especially for people who are novice. And additionally, even without me seeing my motion, I can tell that he's afforded me what's called liberal construction of my pleading, which most of us who may have done something self-represented or in our studies as self-represented litigants understand that we have a right to have our pleadings liberally construed to do substantial justice. Sometimes, you may have a judge tell you that your document is not legally sufficient. That in Florida, for the most part, applies to something like, actually, I shouldn't say that. Make sure I don't even say what I was getting ready to say. I've seen legally sufficient come to me in the form more often of a disqualification of a judge. In most cases, they say it's legally insufficient, and that may give you grounds to appeal their decision based upon the legal sufficiency of a pro se's pleading or a self-represented litigant's pleading, because it may violate their right to adequate due process of law. Again, not legal advice, but my understanding based upon my experiences.
Okay, so they're alleging, is the allegation that the busted taillight is a violation of Florida law, a civil infraction, and that was the reason for the stop? Okay.
Okay. With that being the case, then if that was the violation that would have preceded the event, beyond some discretion, why is there no citation of the busted taillight? Because what I'm gathering is that's not why he stopped me, based upon his testimony, but based upon what's in the report. So now there's a conflicting.
Well, but see, that's different if there's a conflict, but you're also qualifying your own statement. you're suggesting there's a different reason in the report that explains why you were stopped. In other words, if there's no other reason why you were stopped, there wouldn't be a conflict with anything. So I'm assuming the report says you were stopped for a broken taillight.
No, it states that I was stopped because he observed me traveling or driving without a license.
No, this is what it says. This infraction was 3 traffic stops.
Okay, let's stop there, because I need you, I don't know, Madam Court Reporter, are you getting her on the record or no? Okay, so the report seems to indicate that because your taillight was broken, that you were stopped for that reason. Okay, rightly or wrongly, I'm not commenting on the propriety of that, but you're asking me, is there a reason disclosed in the report as to why the officer may have stopped you in your vehicle? That's the reason. And I'm assuming that's what they'll testify to at trial.
Okay.
So let's stay on the discovery issue, because I'm not gonna, I'm covering your motion, and the motion deals with whether you got the information that's in the possession of the state. What else haven't you gotten that you believe you're entitled to?
I'm going to tell you that I have a page that doesn't have that. It says he observed the defendant driving without a license.
Well, there could be other aspects to that, but what page are you on that refers to that?
That would have been before what she just read.
Right.
5. Go to page 5.
6.
Go to page 5.
Go to page 6.
I'm on page 6. I see that.
Page 5 now is the case summary, which will say what the summary is.
Okay.
Page 6 and page 4.
Okay, so do you have page 6, and does it say what she represents? That the officer saw you with a bus, driving with a busted taillight? I'm not saying it's true or untrue. I'm just saying, does it say that's the reason?
On page 6 it does.
Okay. All right. Well, that's the reason. That's what they're going to rely on
There we go.
to explain why you were stopped.
Here's page 5. So let's see up to page 5 where it states clearly, I want the record to reflect. The listed defendant was observed operating a motor vehicle without a valid driver's license.
Correct.
Okay.
That would be a byproduct of the stop. In other words, listen, I'm not going to explain the legal nuances because I don't think that would be correct for me to do that today. The question was, does the information given in discovery explain why you were stopped? And based on what I've been told, you have a copy of that report, and it does address that issue. So again, you have other arguments here that may relate to what you're suggesting, but as to, unless you have something else, the demand for dismissal under item 2, I believe that the state has provided what they're legally required to in terms of discovery, and I'm going to deny the demand for dismissal as alleged for failure to provide adequate discovery.
Okay.
All right, number 3, failure to provide proof of jurisdiction on the record. I'm not even sure what the legal argument is on that. I've already said that I have jurisdiction based on both Florida statute and Article 5, Section 6 of the Florida Constitution. Is there some other specific allegation outside of the federal argument that I don't have jurisdiction?
Well, the issue is it a criminal offense or is it a civil infraction? Because if it's an infraction, that's substantially different than if it's a crime.
I'll answer that question. Driving a license suspended with knowledge, in this case, is a criminal violation under Florida law, depending on your prior record, but it's not alleged that you have a prior record, so it would be a second-degree misdemeanor criminal offense, and that's what we would proceed under at trial, unless something changes.
Okay.
Okay? So, as to the jurisdictional issue, item 3, I'm going to deny the demand for dismissal.
I'll object on the record and I'll just take it with it. I'm sure.
That's fine. Number 4, demand for dismissal. Accuser has not been identified. And what other information? And again, I understand you've been given a copy of the reports. In the reports, there's an identification of who the officers are that would testify and relating to the incident. And maybe in the police report, each officer states what they did or didn't do with respect to your particular case. So as far as the accuser, the witnesses would be the officers identified in the police report or otherwise listed by the state.
And are those officers the ones accusing me of committing a crime?
Those are the officers that witnessed the crime.
Yes. The answer is yes.
For the record.
Okay. So based on
that is actually within something that's signed. Are they going to they're going to come in and testify to that.
To what?
That they saw a crime committed.
Yes.
Okay.
Yeah, they're going to testify that you committed the offense in their presence of driving with a license suspended with knowledge.
We're both almost on the same page. I say, are they going to testify that they witnessed a crime occur?
Yes.
Okay.
Yeah. Okay. What they're going to say is, and again, I'm guessing because I don't read the report. Why don't you summarize what you think they're going to say?
They will say
Offer what they're going to say.
I would assume they will say that they saw the defendant driving with a license, driving, and while he was driving, he had a suspended license.
Okay. That's going to be the alleged offense. I'm sorry?
Is that right?
Yes, I've already answered that. It's a second-degree misdemeanor offense if they prove that you had knowledge of the suspension. That's the charge.
Okay. I believe that's the next thing. I think it's an inappropriate application of statute as well within that.
Well, they can charge something that they may not be able to prove. The threshold for charging someone is not beyond a reasonable doubt. It's probable cause based on whatever facts they reasonably relied on at the time.
Again, what he said is true. The standard for stopping somebody and doing whatever else is kind of low. The standard for convicting somebody of something that they stopped them for is much higher. It's generally much higher. So just keep that in mind. They can charge you and be wrong in charging you. In most cases, the case could be dismissed and should be dismissed. But these are for issues that we have to make as individuals as far as moving forward with any case. But in this instance, as you'll find out later on, I had enough to get the case dismissed, which is going to happen. But again, in looking at this case years later, after traveling on down the road a bit, I know that this could have been taken care of a lot quicker. But again, I wasn't as informed with some of these procedural processes then, and definitely not as much as I am now. And it's worked out for me.
Whether they can prove it beyond a reasonable doubt, that's a higher threshold, and I don't know until we actually begin the trial.
Right, I appreciate
the trial's
that.
over.
But they're not charging. They allege that she charged, correct?
Yeah, it's brought under the jurisdiction of the state attorney's office based on the charging document. In this case, it's a traffic citation issued by the officer under the rules of traffic procedure. That would be the appropriate charging document, unless they filed an information on their own, which I don't believe they've done, correct? Okay, so the charging document that would bring the charge, that's the citation that you received.
I appreciate that clarity on that one.
Okay. All right, so we have number 4, I've denied. No injured party has filed an affidavit. I think we talked about what that's the allegation is the citation is that they observe you committing an offense of driving with a license suspended with knowledge, which is the criminal charge, a second-degree misdemeanor, and that's the nature of the charging document, and that's the case that will go forward. So as to number 5, unless you want to put something else on the record on that issue, I'm going to deny the demand for dismissal for that reason.
Well, if we turn to State versus Allen, and it outlines clearly everything that's necessary for a crime to have been committed. So a crime, just like the water you're drinking, has elements. And it could be hydrogen, oxygen, any number of other things, but if it's not H with at least 2 O's, it's not water. It's something else.
Right, that's
So
absolutely
if they're
correct.
charging that is a crime, then the necessary elements for a crime have to exist, and then we fall into the realm of corpus delicti. So it has to be an
Only if,
charge.
well, they would have to, if it's going to be an issue about statements potentially, but that's where corpus delicti comes in. But outside of that issue, you're absolutely correct. They would have to prove each and every element of the crime and have to prove each and every element beyond a reasonable doubt.
Hey, it's interesting how divine intervention kicked in. He just happened to be drinking water, and I was trying to figure out when I was getting ready to go into my explanation, which he verified about elements of a crime. He just happened to pick up a bottle of water, and I noticed the water in it, and it brought the whole idea of the necessary elements, because as we all know, it could be hydrogen and oxygen, but if it's not properly put together, it's not going to be water. It could be hydrogen oxide and something else. But it was just interesting that all kind of came together at that precise moment in time.
There's a jury instruction on reasonable doubt. There's also a jury instruction on the offense itself, what the elements are. If you don't have a copy of that, they're available online. But those are the elements that they would have to prove, each and every one beyond a reasonable doubt. So you're correct in that.
Okay. I just want to make sure that's on the record.
Yeah, that's fine. So we're on number 6, failure to state a claim, unless there's some other. The uniform traffic citation has been approved by the courts as a means which to charge certain traffic offenses, okay? And outside of some deficiency in the citation itself that you would like to tell me about, the uniform traffic citations have been approved by the appellate courts as being sufficient legal authority to charge someone with a violation of a criminal traffic offense.
Okay, and with that being duly noted, the issue of traffic then comes in because we go even before the slaughterhouse cases with the Gdnapsc versus Ogden. If you're talking about traffic, through definition, people can't be traffic because then we have an issue that becomes volatile with the 13th Amendment. I just wanted to be on the record.
Sure.
If there's
That's probably a bunch of senseless rambling. I don't. In listening to myself, I'm thinking that doesn't even make any legal sense. I may have given them a little background into my knowledge of some history or legal history, but nothing that has any factual bearing on the case that I had before him at this time.
saying it's a uniform traffic citation, traffic is defined.
There's multiple things in the citation. If you look, the citation will have multiple categories. There are actually some that would be criminal, some that would be civil, but it was a way for the officer to potentially charge someone with an offense in a more expedited fashion, considering it as a traffic violation. In this, I'm assuming, and again, I can look at what's in the court file, it looks like there is a uniform traffic citation. It alleges driving with license suspended with knowledge. It alleges a specific statute. It also alleges or checks that it's a criminal violation. And so those would be the things that the standard form would require as a minimum to allege the offense. It also alleges the location, apparently, of where the offense occurred, or the stop at least, East Martin Luther King Jr. Boulevard and North 37th Street. And so that information is contained within the citation.
Yes, sir.
So if the issue is number 6, failure to state a claim, and I've reviewed the criminal report or the traffic citation based on what's alleged in the citation, I believe that is consistent with case law and legal authority. That is legally sufficient to state the alleged offense. So on number 6, I'll deny the demand for dismissal. Now again, that doesn't mean you're guilty of it.
Right.
It doesn't meet the minimum threshold in order to state a claim for which the state can go forward, and I believe it does. All right. Number 7, unethical filing and breach of duty by public. I have no idea what that is.
Just for the record, I just handed him the amended notice of discovery, so that he has it.
But you mailed it out earlier.
I'm misrepresented by my secretary. It was prepared on
19th. That's fine.
Well,
That's
no,
today.
it was prepared earlier, but our office has been told we have to deliver everything to Mr. Doss because there's an issue with getting mail. So
Okay.
they left it
All right.
around.
But you got it.
Now, here's what's interesting about her statement about misrepresentation. Everybody get your notepad out and put a little asterisk by this, by the 2 terms I'm about to give you. Deliberate omission of a material fact and the intentional misrepresentation of a material fact. See where that leads you when you finish your legal study, and if you don't have an answer by next week, just email me. We'll address that.
A copy of the police report and the individual is identified in the police report.
That's
You
right.
received that before today.
Yes, and I just delivered the amended discovery.
Okay.
I was gonna say, I want you to proffer where it was stated there was going to be a difficulty getting the mail, but I'll deal with that at another time. Is these 2 people, one of them is the same. Actually, you spelled his name correctly, so that's okay. And now the badge numbers now shifted. As long as they're accurate, I'll get to that later because
I don't think, unless it's an issue of identity, in other words, was that the
Yes,
person who allegedly observed what they're going to testify to?
Yes, sir.
I think the identity by name is the significant information. But again, if there's a discrepancy and there's an issue at some point or even at trial, and
I can explain that, Your Honor. So
Okay.
At trial, you want to explain it now?
I can explain it now, but the
Sure,
name
go ahead.
was incorrectly spelled, and as soon as I
The name
noticed,
was incorrectly spelled. Okay,
so as soon as I noticed, I changed her from Mr.
What about the badge
Badge
number?
number.
Because it was, when they put the name in incorrectly, it had, like, kind of automated in the system as a different individual.
Are the badge numbers correctly disclosed with the individual officer now?
Yes.
So he,
And they were correctly disclosed, but the police report says, the identification number is for each officer.
okay, so what she's representing is that the information in the report where the officer is identified by name and badge number, that the discovery that you've been given is consistent with those numbers. And if it's not, you can address it with me as if it concerns you, but she's saying that that information is now consistent. All right, let's go back to number 7, unethical filing.
No, can we go backwards one more? The issue now becomes, because I guess maybe my mind might have drifted for a moment, not that I'm not paying attention to you. You're very detailed and I can appreciate that. The issue of the officer's burden of proof, because they're claiming something that now we don't even have proof existed. So now there could be a profiling issue involved or any other number.
I'm not sure what in other words, you may or may not believe there are ulterior motives.
Oh, I definitely believe there are ulterior motives.
Well, whether there are, there not, I don't have evidence either way, but what's articulated in the written narrative, in the written report, is that you were driving with a broken taillight. The officer believed that was a civil infraction, meaning there's a Florida statute that requires your vehicle to be maintained in proper maintenance and condition, and that if the taillight was cracked or broken or whatever he testified or alleged, that would be a reason to stop your vehicle and issue a citation, and that's the alleged reason. Okay. The profiling, I don't.
Well,
that I don't know.
Well,
there's no evidence of that.
For a clarity issue, I don't care what he looks like. Doesn't mean he can't profile, especially if he's under instruction. And I got case law for that too. I'm not worried about that part. The issue now becomes if he's stating that I did something specifically, and we have no proof that any of this took place.
It's his testimony.
It'll be his testimony, right?
His
And officer's
observations.
testimony cannot rise above. If I say my taillight's never been broken, I bring in the mechanic who maintains my car and say, no, it's never been
Then
broken.
it's a matter of credibility.
It's a matter of
always a matter of credibility.
Okay.
And there's a specific jury instruction that deals with credibility of
Take to that
witnesses.
board there.
I don't know why I even brought up the voir dire, but when he brought up credibility in the jury instruction, witnesses are always valuable when it comes to that kind of thing, but as to jury instructions, if you ever want to know what it takes to prove a case or to have a case disproven because it's missing, just whatever the situation, whatever you're charged with or whatever is being alleged, go look at the jury instructions. The jury instructions will give you a pathway to your relief or will give you an idea as to how badly you're going to get punished. Check out the jury instructions, people.
Well, there's like 8 or 9 or 10 factors that I'm required as the trier of fact to consider in determining who is credible and who may not be credible, and I'm entitled to believe or disbelieve already part of the evidence or the testimony of any witness. But I'm going to follow the jury instructions with regarding who I would determine to be credible.
Okay, I appreciate that.
You don't have the burden of proof. I want you to understand.
I definitely recognize that. Yes,
you don't
sir.
have to say or prove anything. It's whether they meet the burden or not. But you may choose to present witnesses at the end of their case. That choice would be up to you.
So I guess my other question is, and I just may be unclear because I'm definitely not all knowing. Is there a law in the state of Florida that states that taillights have to be operable?
Well, that's up to you. You're representing yourself now.
Well, no, I'm presenting myself, but I guess I'm asking that
You
question.
have to find out.
Okay, I'll definitely do that.
Well, if you don't believe there was a proper basis for the stop, you've already alluded to a motion to suppress.
Okay.
If there was no legal basis to stop you, and you find that to be true based on maybe even what the police are saying happened, then of course you can file a motion to suppress, and I'll entertain that motion on legal grounds.
Right, we'll be doing that.
Yeah, that's okay, if it exists. All right,
Yes.
I'm going to go back to number 7. I don't understand the unethical filing of breach of duty. In other words, I'm not saying I don't understand it. I don't have an argument that supports the conclusion at this point that anyone acted unethically or breached their duty in the capacity of a public official.
Okay.
So absent anything else, I'm going to deny a demand for
Well, is a
dismissal
police
on
officer
number
a public
7.
official?
I'm sorry?
Is a police officer?
Yes.
Tampa, a city
Yes.
police officer is a public,
Yes.
public official?
Yes.
They have.
Okay, in asking that question, I'm sure it had to have something to do with something. I'm doing down here at the same time that I'm listening to this, but that whole issue about public officials and all that stuff because of police officers, I'm almost positive that's something I either got from people who were just saying things, or I doubt I got that on the internet, but that's not even relevant in this instance, unless I was going to make an allegation that he was some regular Joe Blow impersonating a police officer. There was nothing to a lot of that foolishness. So keep that in mind.
I'm sure they do, like anyone else. The public official, usually they take some type of oath.
If they receive public funds, they have to.
I would assume that they do, yeah. I'm not an expert on the City of Tampa Police Department procedures regarding employers or employees. But there's nothing alleged or that's tangible factually that I see that I can make a finding that happened. Okay. So you may allege profiling, but I don't have any basis upon which to draw that conclusion at this point. So number 7, demand for dismissal, I'll deny that. Okay. Number 8, tell your state attorney to provide certified copies of all oaths and bond information of involved parties. Why is that relevant?
Because everybody takes an oath to uphold the Constitution.
My answer here is some more what I would consider today to be more mindless banter, or something that would probably be better in a situation where I'm trying either to make some sort of point. What point at this point I don't know, but it really had nothing to do with the facts or the merits of the case before us.
Nobody takes an oath to uphold statutes. And my question becomes at that point, if you took an oath to uphold the Constitution, I expect everybody to execute it. Because if you don't execute it, then the governing authority responsible for your employment has to remove it.
Wouldn't that be a question you would ask during trial? In other words, I mean, if it's even relevant to the issue, the actions of the officers, whether they were legal or illegal or lawful or unlawful, those would be determinations I would make, whether they took an oath or not. I mean, if an officer engaged in conduct that violated the United States or the Florida Constitution, the fact that they took an oath to maybe uphold the law would be irrelevant to my decision that they did or didn't violate the law. I would make that objectively based on the facts presented at the time. I would have to make that judgment.
Right. I would hope.
So in other words, judges rule on issues of law, juries rule on issues of fact, and what he's trying to do is to keep everything moving in the proper direction to get the case going forward. Again, that's some more mindless ramblings from me, again, based upon the passion of my ignorance at the time.
Understand that within the function of the trial. However, if prior to getting to the trial, we discover that, well, now you're operating outside the Constitution to move the case forward.
That's a legal argument that you would have to make representing yourself is to raise the issue in an appropriate motion and allege specific conduct or activity on a factual basis that would then give you a legal argument. Okay,
let's pick this back up from where we just left about him making the factual basis statement. So I'm going to back it up, play it, and we're going to keep on moving forward.
Representing yourself is to raise the issue in an appropriate motion and allege specific conduct or activity on a factual basis that would then give you a legal argument that your rights were violated, that the detention was unlawful, and because of that, based on precedent in the Supreme Court of the United States, the remedy is to suppress all the evidence and exclude it from consideration.
And that goes back to my raising the issue of the suppression motion, which is we're going to get to, but we're not going to get to the actual suppression motion because we're going to have a dismissal prior to that. But again, you see him going to say the issue may not be all the other stuff that I'm raising necessarily, but was the stop proper? So that's where the factual basis, what are the facts that led to the stop, which in turn led to the charges being filed. Getting rid of the stop will get rid of the charges being filed, or the filed charges. Not the charge, they've already been filed, but getting rid of the stop essentially negates the charges in most instances. Again, not legal advice. just basing it upon my experiences.
I would do that, consider that, if you raise it in proper form or fashion. Whether I would grant it or not, I don't know, because I haven't seen the substance of what you would allege.
Okay.
All right, so for number 8, at this point, I don't believe that's necessarily relevant information to the proceeding, and I'm gonna, it's not probative from my perspective, and so I'm gonna deny the demand for dismissal.
Am I not going to be allowed to have a copy of their oath so that I can provide that in the event we go to trial? I would like to show the jury that they took the oath.
You're not gonna have a jury trial.
Well, I want a trial by jury.
You're not gonna have one. You're not entitled to a trial by jury.
That would become pretty interesting.
Now, pay very close attention as he takes us down this historic road. This will be a little lesson in civics and some fundamentals of common law, particularly as it relates to the state of Florida.
It is gonna be interesting because you're not entitled.
Why would I not be
Because it's a
entitled?
second-degree misdemeanor, and it's not a trial. It's not recognized as a trial by jury of common law. You can investigate that all you want, and if you have another issue, you can file a demand or do whatever you want. And again, I'll put it on the record, the reasons for my ruling.
Okay.
But you've been charged with that, and if you're convicted, I'm not going to impose a period of incarceration or probation.
Right, and that actually is on the record. I know it has to be
I'm
filed
going
as
to write
well.
it. I'm going to do it. Yeah.
Now, what's interesting with that is not a jury trial, but a trial by jury. And I know I'm kind of anal when it comes to words because they do mean substantially different things. And if we roll back to the Rule 73 issue, which I didn't bring up here, so
Letter
maybe
Rule 73, is that a federal?
because I'm not consenting. Yes, I'm not consenting to the issue as it is, and I've already
Not
filed
consenting to what issue?
to the engagement or I'm not consenting to the proceeding.
Again, I'm going to just come out and say, in thinking about it today, I'm like, what in the hell am I talking about? And if somebody knows something about this, they could definitely put it in the comment section, what have you, and we can address it in a subsequent video. But I don't want to start traveling back down that road for people who might be in these situations about if you don't consent to it and you send the citation forward with the do not consent and writing letters on it. All that stuff, as you see, hasn't kept them from moving forward in this proceeding, and I believe I might have did it in a couple of other proceedings, and they just kept on moving forward. It didn't matter. I'm not even sure I've been raised them after this right here. I just began to focus on the issue that led to the alleged stops, and we'll go back and look at a little bit of stuff a little bit later on as well.
And that's within the challenge to the statute.
You
Okay.
can preserve whatever you think your rights are.
Okay. So I just wanted to put that into the
I'm going to go forward based on my understanding.
Right.
And I'm giving you every opportunity to preserve your rights that you believe you have in a way that there's absolutely no confusion as to my rulings, and you're not denied the right to preserve your issues.
Yes, sir.
If you decide at the end of the day, if the result is not what you anticipated, that you have every right to appeal.
That piece, that portion he gave us right there, is a jewel and a gem. And what jewel, gem, they're about the same. But anyway, he's essentially telling me, hey, look, I'm giving you this. So if you come back on appeal, the appellate court will see enough of the transcript to say, hey, listen, he's had every opportunity to preserve these rights. Is there a legal basis to what he's saying? Even if the appellate court has to review it for any number of reasons that could show that there's a due process violation, which would require them to reverse his ruling, and it may just reverse his ruling and make him give me a new trial or non-jury trial or what have you. But he's essentially making sure that I have my plate set well in the event I have to move forward. And this is something we should all keep in mind. And again, I get a lot of appreciation for him because I don't think I would have moved forward the same way had it not been for the manner in which he handled this case. There's no telling what could have happened historically as it relates to me traveling down this road and actually having this to give to you all.
Yes, sir.
No
We'll
problem
preserve these
with that.
things
But
for.
I'm trying to explain as I go so that you don't, hopefully you don't take it as being completely arbitrary or capricious. I believe in my rulings, and I believe they're correct, and that's why I'm doing it the way I'm doing it. So for that issue, though, we're not going to have a jury trial. But if you want to file any paper regarding that issue, I'll certainly give you the opportunity to preserve the record in a way that you think is appropriate as to that issue. Okay?
Okay. and I guess since we're only here to discuss the issues relative to.
I'm going to discuss the issues that you
File for, right,
Yes,
right, so I'll file
I'm not ruling, I'm not going to make a definitive ruling, but again, I'm going to give you the opportunity to address the issue, but unless it was a crime recognized under common law at the time of the United States Constitution or the state of Florida Constitution was adopted, then, and those are petty thefts, criminal mischiefs, those are typical crimes that would have been, even if it's a second-degree misdemeanor, you have a right to jury trial. Driving with a license suspended with knowledge is not such a crime.
There we go. Yes.
And it's a second-degree misdemeanor as alleged, and under the laws of the state of Florida, you're not entitled, and I'll do an order of no incarceration, okay?
Yes, sir.
All right, demand for dismissal number 9, improper application. I'm not sure what the argument there, how that contravenes the 14th Amendment, so you want to put something on the record?
Yes, sir, for the record, and I appreciate that, and
Hey, listen, I wanted to say something about this motion, this non-incarceration document. And let's see if we can go in here and find some of this stuff. These are complete projects. We don't want that. Close that out. Close that out. And I know that it's in here somewhere, and just bear with me. But he did do a notice of non-incarceration. I'm trying to find out what I did with these things. Okay, it's going to be in here somewhere in the list of events. But I actually have the actual notice of non-incarceration. I thought I'd saved it somewhere. I'll find the thing. It's in here, I'm sure. But everything that he said he was going to do relative to remaining honorable throughout the proceeding, he actually did. And it did help me get the desired relief that I was seeking. I'll find that other stuff a little bit later on, but I do know that it's in here.
I probably should say this way because I don't want it to be misconstrued. I respect what we're going through right now. This is a dialogue, so I never thought that you would do anything arbitrary or capricious. Just to make sure the record is clear on that.
Either. That's why I want to. I want to do this in a way that you get to express yourself as clearly and as accurately as you can, and my rulings respond in kind, so that if at the end of the day you don't agree with the outcome, you certainly have a very clear, articulate record that someone else could review in terms of what you believe your rights are.
Right, and the onus of invoking rights does lie on the individual, so I appreciate that.
Now let's go back to the improper application. You have to explain to me how that contravenes the 14th Amendment.
Okay.
If it does.
Okay. Essentially, the whole, which you kind of narrated it already, you can't create, no state can create laws that would, in effect, limit the rights, privileges, and immunities of the citizens. So, and also, not just the 14th Amendment, because that's an equal protection issue, also it's a bill of attainder issue. Because you can't legislatively punish somebody without due process. And actually, that's Article 1, Section 18, it's an administrative punishment. I don't recall.
How does that relate to the 14th Amendment?
Well, because now you created something that the 322.334 is a law created to punish somebody without judicial process.
Well, I wouldn't agree without judicial process, because obviously we're in the middle of a judicial process here right now.
But they're alleging it's already done.
I'm sorry?
But they are alleging that the action was already taken.
The crime was already committed.
Right?
The issue of the judicial process is the opportunity to review whether the allegation, the crime, can be proven consistent with the standards of reasonable doubt. That would be the application through the judicial process. The 14th Amendment is a due process requirement that the laws of the United States Constitution are applied to the state, right, so that you don't have a disparity, and obviously you know the history of that, you don't have a disparity in how citizens, no, I'm saying you,
very well, yes,
well, you understand it because you alleged it, right. You understand that it was to make sure that constitutional fundamental rights could not be deprived to individuals under state law. That's really the essence of the 14th Amendment.
Given that today is June 19th, it makes all the sense in the world. But
I have no idea what that means, but just so you know, I don't.
Juneteenth.
But I don't know what Juneteenth is, unfortunately.
That's the date that many slaves found out they were actually free.
Okay.
Now, that's just universal intervention, giving me an opportunity. Well, when he it just so happens that this did take place on June 19th, 2015, I believe it was. But we discussed it, and as you can see, a lot of people probably weren't aware, even judges were aware of that, and it's pretty evident that he's pretty well informed about quite a few things. But I just thought that was a pretty interesting segue for me to make the statement. A lot of the other things were just, again, me passionately wanting to defend issues that may not have been properly before this court, but nonetheless, he gave me an opportunity to explain things and actually lay a foundation as to why I believe that the stop was not just the stop was improper based upon the reason they're going to give for the stop, but that any reflection of what happened with the license is improper because of other processes. I just didn't have the ability to articulate it and put it together in a manner that would have made as much sense then as I could probably do it, I'm sure I can do it today.
I learned something today. But if your argument is that the application of the statute
is improper,
well, again, the contravention of the 14th Amendment to me deals with fundamental constitutional rights, and I'm not sure what that fundamental constitutional right would be implicated by you receiving this citation.
to state that I need a permission,
correct,
to move,
okay,
would be otherwise in contravention of the 14th Amendment to the Constitution.
Okay, if that's the argument, then I don't believe that given that you do not have a fundamental constitutional right to drive, and obviously I believe the courts have recognized that there can be limitations upon that, for example, requiring you to get insurance, requiring the vehicle to be registered. Those requirements inherent in the right to drive or the privilege to drive have been recognized under Florida law and as being valid restrictions. You have to get a driver's license to drive. You have to meet requirements to get a driver's license. They can limit your right to drive certain vehicles based on the type of license that you have. These all fall within the purview of does a state have a right or have the authority to limit what is been perceived as a privilege, not a fundamental constitutional right to drive.
Those, I may still disagree with him a little bit on that, but the issue becomes whether or not the state has the right to create policy that ultimately affects and protects its citizens, its residents or its citizens of that state, and also whether or not a state has the right to create its own set of police powers, so long as those sets of police powers are not in contravention to the United States Constitution. So even though I may disagree with him a little bit with that, the gist of it is still the same. The state can set out these prescriptions, regulate, in other words, certain issues, and then so long as those regulations don't violate well-established rights, fundamental rights that are protected by the 14th Amendment, which, because the 14th Amendment is a federal law that is applicable to the states.
So for that reason, I'm going to deny demand for dismissal as to number 9. I do believe, consistent with the legal authority I'm required to follow, that there is no fundamental constitutional right to drive an automobile.
Okay, I'll object, and on the record, let it be noted as well that a license by definition is permission to do some act which otherwise would be unlawful, to which the licensor could take from the licensee. Now, the issue of the license in and of itself is that the license allows anyone to go out and make a living. The ability to move from one spot to the other is governed even in international law.
Right.
Okay.
In your argument, you're suggesting that you have a right to move, a freedom of movement. Is that your argument?
That's the inclination.
In the context of driving an automobile, and again, I just want to make sure that I'm trying to explain it to you. I do not believe you have a constitutional fundamental right to drive an automobile in the state of Florida, and because it's not infringing upon a fundamental constitutional right, I don't believe it contravenes the 14th Amendment, and that's the reason I'm denying your demand for dismissal as to that argument. Now, you've made the argument,
I'll articulate it.
But I want to let you know the reason for that.
I'll articulate it in writing and put it into the record.
No, you've done a good job of it. I understand.
And that way I can go ahead and change the venue. So, okay, that needs to be addressed because there's fundamental issues in that.
We already addressed the jurisdiction of the court. That includes venue. So the alleged offense happened in Hillsborough County. and jurisdiction would vest in the 13th Judicial Circuit, which includes Hillsborough County. And that's the only county actually in the 13th Judicial Circuit is Hillsborough County. All right, number 10, demand for dismissal. I'm not sure as to the requirements. I think we talked about what's alleged in the citation. It's a uniform traffic citation. The information alleges both a violation of the statute. Specifically, it alleges that it's a criminal offense. There's a box check for driving license suspended. It identifies you by name. It also identifies the alleged location of where your vehicle was stopped. It alleges the name of the officer who issued the citation. And so based on that, is there another argument that the requirements of the statute are not satisfied? And again, proving it is not the same thing as giving you a citation, and all they needed was probable cause to issue the citation. Whether they can prove it or not, that's another day.
Right, the probable cause has to rise from something that's articulable and provable, and I just want the record to reflect that. And as we have now been given the discovery, there's no proof that anything went on. More importantly, there's a Fourth Amendment issue to the U.S. Constitution in Article 1, Section 12 issue as well, because
that's unlawful search and seizure for those following along, keeping score. Hopefully, don't get too distracted by the stuff I'm doing in the background. I wanted to get this kind of done and out of here, but let's. I wanted to have the documents prepared for you once we get this done. We get through this segment here.
If they observe,
well, here's what we're going to do though. We're already at about 45 minutes for a 30-minute hearing. Okay. I'm gonna address your issues alleged in this document. And again, if you need more time to argue additional facts, we'll work that out. Okay. But as far as improper application of statute 322.34 as the requirements, I'm going to find that the charging document, meaning the traffic citation, is legally sufficient, and therefore I'm going to deny demand for dismissal under number 10. We already number 11, the corpus delicti, that involves the elements of the offense. They would have to, and that's also number 12, they would have to prove each and every element of the offense as set forth in the statute and as delineated in the jury instructions. And until such time as the evidence is presented, I don't believe that there is an appropriate basis to dismiss the case. And again, it would depend on whether the state proves each and every element at trial. Okay?
Yes, sir. Now, for the record, the charging function issue, because I'm a little unclear. She's charging or they're charging?
The citation, the authority to bring the case is going to be with the state attorney's office. The individual that issued the criminal citation, which they are now prosecuting, would be, is it TPD?
Okay.
Tampa Police Department. So the arresting agency, or the agency that observed the offense and issued the citation, would be the Tampa Police Department. However, the legal process by which that claim is litigated in court, the jurisdiction or the authority to bring that case is within the state attorney's office for this circuit. So, but that's a different issue than 11 and 12. And so again, and these all go back 11, almost every one of them, starting at 10, 11, 12, 14. They all have to address the issue of whether there's sufficient evidence presented on the record at this point to allege the crime, and I think there is. I think based on what's been filed and prepared or issued by law enforcement alleges the offense of driving license suspended with knowledge, and so the other elements, or the elements whether they can be proven or not, is a trial issue.
And without proof, it's not evidence. So.
Well, but that's what trials are for.
I just wanted to make that on the record. So there's no evidence, and nobody's providing evidence to tell that.
There is, well, the evidence would be, at this point, the evidence would be the citation and the police report. The actual trial itself, to prove whether the crime occurred or not, that would be a function of live witnesses under oath testifying, and whether the state could prove all of the elements beyond a reasonable doubt that you committed the offense. That's the process and functioning of the trial. So as to number 10, 11, 12, and 14, I'm going to deny that demand for dismissal, because I do believe that there is sufficient legal basis for this case to go forward at this point for trial. Notice of challenge to statute of motion to intervene. The state just got a copy of that today. So, let me ask you one more question. You expressed concern over the jury trial issue. I don't know if you have any other motions you want to be heard. And so what I want you to tell me is, are there other pleadings that you want to file before this case gets...
we're going to file a suppression.
Okay.
Notice for a demand for suppression.
Well, suppression is a evidentiary hearing.
Right.
Okay, so that's going to take some time. Let me ask you about the trial. The trial is scheduled for July the 2nd. Do you want to move the trial date, or you?
I'm not going to waive my rights. The speedy trial.
Okay. Well, and again, the April, July. Then you've got. Where are we now? June
19th,
June 19th.
that's what you're
Then here's the thing, though. You have the onus, unless you want to continue the trial. You have the onus and responsibility of raising these legal issues, not only in written form, and you've done that, and I appreciate that, in a notice of hearing, and you've done that, but also timely. In other words, these are issues that would have existed potentially at the beginning of the case, and if we don't get them addressed relatively quickly and timely, I'm not going to be able to hear them before the trial date of July the 2nd.
That's overstood. However, the reason that we're this far back is not because of me, it's because they didn't give me discovery until last Thursday, Friday. Last time I was in here.
Well, here's where we are. Today is June 19th. How many days before trial?
There are
10.
No, it's what, 11, 13? For this to get heard, we're going to need this thing to be done relatively quickly.
I need at least 5 business days.
Well, let's do this. Can you get Brenda to come in real quick?
Yes, Your Honor.
I'll see what I have that Monday.
Now, let me say this also, and I apologize for what's going on in the background. I had to put in that password because I know I have that on my other computer, so I thought that particular subscription to Adobe goes to all of them. I'll fix that later on, so I'll worry about that later. I'll be able to show you the documents I brought up. As to the suppression hearing, which he says an evidentiary hearing, that means I get an opportunity to cross-examine whomever the state's witnesses are. That could have been one of the the preeminent reasons why the state dropped the case later on, but they knew that I was aware that there was SOP within the Tampa Police Department relative to what they should have had as far as being able to prove what they were alleging. And I did have a mechanic to come in, that would have been able to come in and say, hey, listen, this BMW, I think it's my BMW at the time, is always maintained, so that wasn't an issue. I don't know, that's all speculative, so let's not get too far off into that. Let's just focus on what comes from the suppression hearing. An opportunity to cross-examine the officers or officer who is alleging what he saw that gave him pretext for the stop. And I addressed why I wasn't going to waive my right to speedy trial, because their delay in justice could be a due process violation as well. But we got through that, so let's just continue to move on. I think we saw the order of no incarceration, and I'll show you the docket page once we finish up with this portion of the action.
Whatever that Monday is.
Yeah, that's our next motion date to trial.
Yeah, now you've got to file this timely.
I can file this today.
Okay.
Today's Thursday, right?
Today is Thursday, whatever.
I can give it to you.
Okay. So, as far as this, I'm going to reserve ruling because you filed it, it looks like, in a separate document, notice of constitutional challenge to the statute and motion intervened. And I'm going to try to give you a time.
May I have my copy back?
You were giving that to me because I
No, you have one. One is already in. One is already in your.
I thought you were giving that to me.
Whatever. You have one that was received in room 107. You have yours.
I believe this is it.
Right. No, it's the same thing. But because I had to certify one to the state attorney and certify one to the attorney general. So then I wouldn't have any luck.
Okay, that's fine. How much time do you think you need?
To be heard? next week?
No.
Oh, you mean probably an hour, 3 people, right?
We already have 2 hours and a half hours.
Okay, well, we're gonna get it done.
Now, I need to also,
But you're gonna do everything. Now,
Right.
after today, there's not gonna be any issues that are not gonna be heard by then. I'm not gonna hear them. So if you have issues with
well,
already.
one thing, the challenge to the statute, I know you don't want to, but the thing is, if you read
No, I didn't say I didn't want to. I'm not hearing anything after June 30th. So I'm giving.
Oh, okay, that's fine.
I'm just letting you know that that's gonna be the date. If there's anything I'm gonna hear relative to the case before trial on July 2nd, June 30th is the date that you're gonna have that hearing, and then you have to get everything filed within a short period of time. You can't do it the day before. So what you want to do,
I have a couple witnesses also, so I need to give her.
whatever you want to do, we'll have the hearing on Monday. What else do we have? I already have, what, 2 hours set?
We already have, yeah, about 2 hours.
Okay, so here's what I'm gonna do. I'm gonna set you for Monday, June 30th at 3 p.m. I'll try to be as close to 3 p.m. Well, I'm trying not to waste your time.
No,
I'm gonna
sir.
try to be as close to 3 p.m. as I can, and then we'll go ahead and do it at that time. Can you have all the motions filed by Monday?
Yes, sir.
Okay, get them filed by Monday, June 23rd, okay? And obviously, the original gets filed with the clerk, copy to the state, copy to me of any other motions or issues you want me to consider before trial, okay?
Okay, I'll raise the other issue. Okay, thank you. That's when we do it now.
All right, so we're gonna set it for June 30th at 1:30 p.m.
Said 3.
I'm sorry?
3
I'm sorry, 3, I'm sorry? Yeah, I'm sorry, 3 p.m.
3 p.m. Okay.
All right.
The defense has witnesses they need to disclose. They also have a duty to disclose those to me.
I just
You
have
have
to go on the record. I need to give you a list of the witnesses.
Right, there you go. So do everything by Monday and we'll go on.
And I'll provide you with evidence as
30th,
well.
okay?
Now, let me real quickly address the reason that I engaged with the state attorney this way. I won't say that she's incompetent totally and always, but for some reason she just didn't seem to have a lot of things together. And you're going to hear a little bit of that if you continue to listen to some of these my future videos. You watch the future videos. I believe it was the same state attorney, but you'll see that she was woefully ill prepared, and Judge Conrad is going to address her in the next proceeding as well. Some of that was her fault. Some of it, I think, was the fault of the officer who falsely arrested and imprisoned me in that case, which that's a much more interesting case. So let me finish this and close this out.
All right, anything else? Yes, sir. All right, Mr. Doss, thank you.
I
We'll see you
appreciate
back
your
then.
time.
Sure. All right, let's go one more. Who is it?
Okay, so now we have that out the way. And so the only thing we're going to have left is the conclusion video, which would be what came out of what the court's final decision was. So that being said, instead of me doing that as a part of this video, I'm just going to close this video out. I'll do another video that goes only to the conclusion, the case being dismissed, and by then I'll actually get all these documents together so that way the video will flow a lot more smoothly, and we'll get out of here. It'll be a much shorter video. Again, as always, if you want to support the channel, the information is down at the bottom. You can go through Zelle, CashApp, of course, PayPal. Anything would be definitely appreciated. If you have any issues that you may want me to help, or you may want to discuss with me, and I can give you my experience based upon the number of the ones I've had. And when you check out the fourth video, you'll see I've had quite a few experiences. Just contact me using either gregdoss.com. You can call me at the phone numbers. One of my phone numbers is listed on that on the screen. And of course, you can always email me at gdnapsc@gmail.com. And it's always important. Sometimes it's not about right or wrong. More importantly, it's about clarity. You never reach resolution unless you're willing to engage in honest dialogue, even if that dialogue is with yourself. Take time to hug the person you love and love the person you hug. And on behalf of Gdnapsc, I'm Greg Doss. I'm also DJ Squid. I'm saying peace. I'm saying chicken grease, and I'm out of here.